Part 3 of Risk Management and CLC Practice looks at what risk management is, explains the national PII policy, and considers other insurance CLCs may have. This section covers the remaining chapters of the Risk Management Guide. Chapter 3 on Risk Management for CLCs, Chapter 4 on PII and the National PII Policy, Chapter 9 on Cross-Checking Procedures, and Chapter 10 on Other Insurance. Please turn to Chapter 3. Chapter 3 contains plenty of discussion and background information for the reader. It starts with a definition of risk management as the identification, assessment, and prioritization of risks, followed by coordinated and economical application of resources to minimize, monitor, and control the probability or impact of unfortunate events. It covers all legal and non-legal aspects of CLC work. As CLC workers, we need to manage risk to protect our clients, ourselves, both as individuals and as part of our organisation, the reputation of CLCs generally, and the interests of our stakeholders and funders. There are a number of stakeholders who have an interest in ensuring each CLC has sound risk management, and these are discussed in Chapter 3. We are reminded that this should be a client-focused approach. The diligent application of sound risk management strategies by a CLC means a client is less likely to suffer damage from any mistake or oversight. Having an appropriate PII policy in place means that a client who does suffer a loss can be compensated. Chapter 3 also contains information about each person who has a role in risk management and explains in detail what that role entails.
Hi, I'm Catherine Evil. I'm the Principal Solicitor at Welfare Rights. A useful part of the RMG for anyone starting out at a community legal centre is the section that begins at paragraph 3.5.1 of the guide. It's where the roles of the various people in the sector are explained, as well as some of the organisations. It's helpful to see the big picture, as well as to decipher some of the acronyms that you'll hear everyone using. In my role as the PII representative for WA, this is explained at 3.5.11. I often talk to lawyers and responsible people in other centres about their role, particularly when they're starting out. This is spelled out in a lot of detail, and it helps explain the difference between being the responsible person in the centre and being responsible for the legal practice, compared to being responsible as a manager of a centre for employment issues, funding issues, and running the centre as a whole. There's even a helpful section with some suggestions about how to resolve any potential points of confusion or tension. The RMG ensures that we're all on the same page.
Let's look at CLC Australia. This is the national peak body of CLCs, which is governed by a board and advisory committee made up of representatives elected by state and territory associations. It is the holder of the PII policy. Its responsibilities include negotiation of the terms of the PII policy and the ongoing administration of the policy, negotiation and payment of the premium, decisions in relation to financial expenditure and administration, decisions around major policy issues or directions, maintaining and operating the legal investigations cost funds and excess fund. The PII network is made up of a PII representative from each state and territory and a CLC Australia staff member. Its role includes reviewing and recommending changes to the PII policy. It exercises delegated authority from CLC Australia to develop and administer the national PII scheme. It considers, plans, and implements preventative strategies and actions For example, information and education sessions for CLC lawyers at the national conference or via webinars during the year. It is also responsible for regular updates or revision of the guide. Finally, in cases of serious non-compliance with the mandatory standards by a centre, it makes recommendations to CLC Australia as to whether to cease to offer PII cover to that centre. Each state and territory appoints a PII rep. In some states, the role is shared by 2 or more people. The PII rep is described in the guide as the workhorse in the administration of the national PII scheme in their state or territory. They represent their state or territory on the national PII network, convene a minimum of 2 meetings a year of the PII committee in their state or territory, coordinate the administration of the PII scheme in their state or territory, discuss potential notifications with responsible persons, and provide guidance to centres about the insurance policy and the scheme. The PII rep is also responsible for making sure the annual cross-checks go ahead and then reading the finalised cross-checks questionnaires each year and taking any necessary follow-up action. The State PII Committee is a committee made up of the responsible persons at each CLC in their state or territory. It meets at least twice a year to discuss any issues relating to the PII policy and the scheme. In WA, this committee also discusses any legal practice issues affecting CLCs that arise in Western Australia. The Legal Practice and PII Admin Committee is a small subcommittee in Western Australia made up of the PII rep, someone from Community Legal WA, and 2 or 3 responsible people from other CLCs. It meets every 6 weeks and assists with planning CPD training for CLC lawyers, organising the annual cross-check, and responding to legal practice and PII issues that arise for CLCs in WA from time to time that can't wait for the twice yearly meetings of the PII committee. When a new CLC applies to become a member of the State Association, this admin committee will assess whether they are willing and able to comply with the mandatory standards and so be able to join the PII scheme. There are a number of tasks that need to be performed at the state level in WA that are shared between the PII representative, the State PII Committee, and the Legal Practice and PII Admin Committee. PII representatives and PII committees have a proactive and preventative role in identifying any common areas where CLC practice could be improved to enhance risk minimisation. Each centre must appoint a responsible person. The mechanics for this were described earlier. The responsible person ensures that the guide is being implemented and the centre is complying with the mandatory standards. The responsible person should be aware of the contractual requirements of the PII policy and should ensure that the centre develops and implements policies and procedures to give effect to the mandatory standards in the guide. It is their responsibility to advise the PII rep of any PII or other risk management issues arising at their centre, and they are responsible for the centre's legal and related practice. They must discuss any potential notifications with the PII rep and then liaise with the broker and insurer in relation to any notifications and claims. As discussed earlier, where the responsible person decides to delegate some of their supervision responsibilities, they will appoint a nominated person. This chapter sets out relevant considerations and other information about the appointment. The role of the cross-checker during the annual cross-check is also explained in the chapter. We will return to this later in the presentation. Please now turn to Chapter 4 of the Risk Management Guide. Chapter 4 provides more detailed information about the CLC's responsibilities under the policy. A centre has a duty to notify the insurer in writing as soon as possible and while the policy is in force about a claim or loss or potential claim or loss. This is a contractual obligation under the PII policy. Failure to notify the insurer in a timely manner of any claim or of circumstances which may give rise to a claim which you know about or should reasonably have been aware of may result in the insurer later refusing to indemnify the CLC if a claim is made. The responsible person should give notice in writing to the insurer of any facts that might give rise to a claim against the CLC as soon as reasonably practical after they become aware of those facts and before the expiry of the period of the insurance, i.e. by the 30th of June each year. If in doubt about whether facts might give rise to a claim, it is prudent to err on the side of caution and notify. The process required under the Risk Management Guide is set out and is as follows. The responsible person from the CLC should discuss the matter with their PII rep or another PII rep before deciding whether to notify, but ultimately the decision rests with the centre. It may be useful for a centre to discuss their matter with the broker prior to making the notification, but it is important to keep the PII rep in the loop as to what has been done and to keep careful notes of any discussion with the broker or the insurer. The notification form is sent to the broker, and it is important to consider whether there is remedial action the centre is ethically bound to make or take or thinks it is legally advisable to take.
So I'm going to talk about how to make a notification. First of all, obviously you identify that a mistake has been made, and then consider whether that involves a breach of duty to a client. For example, you realise you've sent an email with advice to a client, but you've sent it to the wrong email address. You've received a response from somebody saying, look, I don't know why you've sent me this email, I'll destroy it, but you've sent it to the wrong email. So if you're not the responsible person in your centre, the first thing to do is to go straight to the responsible person, let them know what's happened, and explain exactly how it happened. Then there's 3 steps that responsible person will need to take. First is to notify the insurer. The second is to notify the client of the breach of their confidentiality. And the third is to consider whether practices in the centre need to be updated to avoid it happening in the future. To notify the insurer, it's really helpful to look at the flowchart at page 59 of the Risk Management Guide, because that gives you a step-by-step process of how to do a notification. It involves a discussion with the PII rep in the state, and then completing the notification form, which you'll be able to find on the Community Legal Centres Australia website, and then in the cover letter to the broker explaining what, if any, remedial action that your centre may need to take. For example, getting in touch with the client to let them know what happened. Once the insurer has okayed getting in touch with the client, then it's important to keep a careful file note of any conversation that you have with the client. It's always useful to let them know honestly what happened, but also what steps you're going to take to make sure that the information's retrieved or destroyed and that it won't happen again. And then it's really a good time to look at how did this happen? Is it the email policy that needs to be updated? For example, would it be appropriate to only send an email to a client in response to an email from a client so that you know you've got the correct information, or to send a test email first? Then update any existing policies, procedures to put the new procedure into effect, and then do some staff training around the issue.
A CLC must not make any admissions of liability. This is also a contractual obligation set out in the PII policy. This does not prevent a CLC taking remedial or mitigating action after a potential claim arises, but this should only be done after consultation with the PII representative and then the insurer. The CLC may be under an ethical obligation to correct or clarify advice given or refer the client for independent legal advice. This can be difficult to do without admitting liability, and so it may be necessary to discuss the proposed course of action with the PII rep and the insurer first, and then take the necessary action. Any complaints about dealings with the broker or insurer should be directed through the responsible person in the centre to the PII representative and then to the PII committee or national PII network. As CLC Australia is the contracting party, it is imperative that CLC Australia is informed of any issues with the policy, its interpretation or application. It is important to note that where a CLC has more than one insurance policy, it should consider the risk of double insurance. Where more than one insurer exists, there is the possibility that no insurance will be available because both insurers will seek to avoid liability. Please now turn to Chapter 9 of the Risk Management Guide. This chapter is devoted to the cross-check. The cross-check questionnaire is an annexure to the guide. Please find the questionnaire. The annual cross-check is coordinated by the Legal Practice and PII Admin Committee in WA to monitor each centre's compliance with all mandatory standards in the guide. It is a method of peer review that facilitates good practice and encourages CLCs to reflect on the practice systems in their centre and the ways that they can be improved. All services and projects of each centre are included in the check. It is not a substantive check of the advice or casework provided by a CLC. That is the responsibility of the responsible person in the centre. The cross-check does verify whether the responsible person has put in place the necessary systems and procedures to ensure the substantive legal correctness of all advice and ongoing casework.
Hi, my name's Anne-Margaret Walsh, Principal Solicitor of Street Law Centre in WA. I've been asked to have a chat with everyone about cross-checks. Well, actually, it was my choice of topic. Reason being my choice of topic is we've got ours tomorrow. But having been a Principal Solicitor at Street Law Centre and a Principal Solicitor in another community legal centre for 5 years prior to that, I've actually been through quite a few cross-checks. So my tip for everyone is don't panic. Also, a tip is to always take the good things away from a cross-check, whether it's your own cross-check or actually attending and doing a cross-check of another centre. What I've found over the years is that I've seen processes and forms developed which I've actually been able to adopt at our own centre, which has been really, really useful. And also people coming into our centre and doing cross-check of our centre, they've taken away new and informed ideas. The purpose of the cross-check is it's an invaluable thing, although it can seem really scary at the time. And its purpose is to keep us, I'll use the word compliant, but to keep us so that we're reminded of the risk management guidelines and that we keep ourselves in check in relation to those guidelines. I know the guidelines have been going under review for a little while and we're sorting those out at the moment. But, sorry, I lost my train of thought. Hang on, risk management guidelines. The value of the risk management guidelines and adhering to them though, it keeps our processes in check, keeps us compliant with review notes, keeps us compliant with limitation periods, keeps us compliant with supervision, it keeps us compliant with everything necessary for good practice management. So, and the cross-check sorts that out and identifies if there's any glitches in the process. So I just wanted to have a chat to everyone about that and wish you best of luck with your future cross-checks. Thank you.
During the cross-check, all cross-checkers must sign an undertaking stating that any client and centre information obtained during the cross-check procedure will be kept confidential. Where there is serious and ongoing non-compliance with one or more of the mandatory standards in the guide, the PII representative or committee may have to raise the matter on a need-to-know basis with the State Association, the National PII Network, or CLC Australia. Please turn to Chapter 10 of the guide. There are a number of insurances that CLCs should consider obtaining, such as public liability insurance, which covers loss arising from injury or physical damage suffered when someone visits the centre. Association liability or directors and officers insurance, which protects directors and officers in the course of carrying out their management duties. Workers' compensation insurance. Volunteers' personal accident insurance. Contents insurance. And cyber insurance. You have now completed Part 3 of the Risk Management Guide presentation. If you have completed all sections of the course, you can now proceed to the case study.